Good afternoon, sir.
Greetings to one and all present here. Um, so, are we audible to you, sir?
Yes, yes.
Yeah, sure. Before we begin with the session, I would request Ms. Aditi to take over for the introduction of the guest.
Sure, ma'am. Am I audible?
Yes.
Yes, Aditi, you can take over.
A very good afternoon to one and all. Our today's guest of honor is Mr. Varun Malik. He has pursued Bachelor of Law from NET Law School, Rajasthan in 2010. In 2015, he did his post-graduation from NALSAR, Hyderabad. He did his Masters in International Trade Law and Public Law Theory. He also assisted Professor Amita Dhanda in the revision of N.S. Bindra interpretation of statutes. He joined NALSAR in 2016 as teaching associate. He also assisted Professor Amita Dhanda in the revision of MP Jain and S.N. Jain's book on the administrative law. He is currently serving as assistant professor in NALSAR since 2017. He has several interest areas like in animal rights, commercial areas, international law, and civil remedies, etc. A huge welcome, sir.
So you can take over now. Thank you.
So, thanks a lot for the introduction.
Thank you, sir.
And am I clearly audible to everyone?
Yes, sir.
Right. Am I on record?
Yes, sir, you're on record.
Okay. So, the area that I had chosen to kind of discuss for today's session is largely around the amendment which the Specific Relief Act had undergone in 2018. Although the amendment, it's been some time since the amendment has been made, almost around, it was floated in October, like the amendment, it got notified in October 2018. Now it's almost end of September of this year. So 2 years have passed since the amendment was notified, but still it remains to be a recent advent in the commercial world, for the reason that the effects of the amendment have not yet become evident. It's not something which is still out there that effectively, because first of all, there is a great kind of an uncertainty or an issue on whether this amendment should be considered as what do you say,
Effective?
prospective or retrospective, right? And in case it is prospective, then obviously the cases which will come up after the notification of the amendment, on those cases this amendment will apply. And in case it is retrospective, in that particular case, the cases which are pending before the court, even before them, it will apply. But because it is still a disputed domain, that is this amendment a prospective amendment or a retrospective amendment, because nothing is made clear in the law. So what we need to understand here is that this amendment therefore remains to be recent, for we don't have much of on-record judgments. There might have been some decisions from the lower court or district courts as far as this particular amendment is concerned, but there is not much of decisions on record, which is from the high courts or from the Supreme Court. And even if Supreme Court gets a chance to kind of work around the decisions or to kind of look at the Specific Relief Act in recent times or post the amendment, they many times choose not to kind of speak about the amendment or about the nature of the amendment and stuff. One of the examples is a recent case. It came 2 days back. So I was informed I that you have to take this webinar on 20th. I was like, okay, fine. On around 17th and on 18th of this month, a decision of Supreme Court came concerning the Specific Relief Act. But to my astonishment, in that 94 paragraph long decision, there's just one para in which they have talked about the amendment, and rest they have chosen to kind of be silent on that. I don't know why should Supreme Court do that, but that is not the matter of concern for me in as far as this particular webinar is concerned. I am largely concerned here with that what is the nature of this amendment? How do we kind of look at it, what really it is, and then how do we kind of look at this particular amendment as far as, I mean, in light of the surrounding law and in light of other things, right, as they kind of exist. Now, let us begin with that. What basically is Specific Relief Act? If we are talking about amendment on Specific Relief Act, one important aspect for us is to understand that what is Specific Relief Act. So Specific Relief Act, as the name suggests, is a legislation which basically works around several kinds of reliefs which are granted in certain specific circumstances or in those situations wherein certain specific conditions are fulfilled, right? And in such situations, what we need to understand here is that there is one specific relief which has become extremely controversial when it comes to this particular amendment, and that is the relief of specific performance of contract. So to kind of list, there are several reliefs. There is relief of recovery of property, section 5 to section 8. Then you have specific performance of contract, right? Section 9 to 24. Then you have cancellation of documents, declaratory decrees, rectification of documents and instruments, right? And injunctions finally. So what becomes the most contentious relief as far as our specific relief amendment of 2018 is concerned is the relief of specific performance of contract. Now, what is this relief? As far as the law of contract is concerned, the law does create the requirements. It also does create certain essentials for creation of contract. It also gives certain guidelines for performance of contract, but it does not get triggered unless and until there is a breach. And when you talk of breach of contract, you essentially talk of remedies. And by and large, in the common law systems, which also had equity as a parallel adjudication mechanism, there were two basic kind of reliefs that existed. One was the relief of damages for the breach of contract, and other was the relief of specific performance of contract. The relief of damages originally was a relief in common law or the legal adjudication mechanism in medieval England, and the relief of specific performance of contract was the relief which was basically granted by the courts of equity or the equity courts, or what we also call as chancery. And therefore, the specific performance of contract came to be known as an equitable relief, whereas damages were relief in common. And general understanding was that in those cases wherein common law courts cannot grant an adequate remedy, in those cases wherein the common law courts are not able to kind of further the cause of justice because either damages cannot be ascertained or damages are not an adequate remedy. In that particular case, the litigant or the aggrieved party or the claimant can go to the court of equity or to the chancery and seek for specific performance of contract. This was the arrangement in medieval India. And when countries like India, but we are concerned with as far as this webinar is concerned, when countries like India got colonized, and as a result of colonization, the Specific Relief Act got introduced in India, right? In the colonized India, the Specific Relief Act of 1800s, it kind of reflected or kind of furthered a similar kind of understanding of specific relief or of specific performance of contract, right? It basically said that wherever damages are not adequate remedy or wherever damages are not ascertainable, the court, if it deems fit, may grant specific performance of contract to the parties, right? And this rule, which said that where damages are not adequate in nature or where damages are not ascertainable, came to be known as the inadequacy test, which is where damages are not adequate, we will grant specific performance of contract. What this amendment does is that it makes specific performance of contract, which earlier was an exceptional remedy, which could only be granted in those cases where damages did not do good, right, as a alternate remedy with damages. The amendment, if you look at the committee report, I will analyze that report in quite great detail in this webinar of mine, right? If you look at committee report, the committee report goes to the extent of saying that we want specific performance of contract to be the primary remedy and damages to be granted in those cases wherein specific performance of contract is statutorily barred for certain reasons, right? So that is the effect of this particular amendment. See, there are several changes that this amendment has made. Some changes have been made under section 5 and 6. Then you have a completely new remedy, which is substituted performance, or what we also call as the remedy of cover under section 20 of the Act. Some changes have been made to the provisions concerning injunctions and all, but I am restricting, because of the time constraint, I am restricting myself only to the discussion around the most major amendment which can have severe implications on the commerce, which is the amendment which makes the specific performance of contract as an alternate remedy or as a regular remedy, which in its original form, or which under the erstwhile Act prior to amendment was essentially a remedy which was discretionary and extraordinary in nature. If you look at the judgments of the courts, they time and again say the specific performance of contract is an extraordinary remedy, right? But what this amendment has now done, it has made it a regular remedy, right? So that is the basic idea, right? So now if you look at section 10, earlier section 10 would say that the specific performance of contract may be granted at the discretion of courts in the circumstances wherein damages were either not an adequate remedy or could not have been ascertained, right? But if you now look at the current section, it says that specific performance of contract shall be granted, thereby creating a mandate that specific performance of contract shall be granted by the courts. Again, they have removed may and the discretion part from section 10, and also the corresponding section to which talks about discretion of the court in specific performance of contract. The section 20 of the earlier Act has also been removed, right? Now there is new remedy under section 20, which is the remedy of substituted performance. But let's kind of come back to section 10. It says that the specific performance of contract shall be granted in those cases wherein the litigant seeks for it, subject to the restrictions under section 11, 14 and 16 of the Act. That is the effect of new section 10, which means that except for statutory restrictions under section 14 and 16 and section 11 of the Act, under all other circumstances, the specific performance shall be granted, which is taking away the discretion from the court, and at the same time, it is taking away the taking away the extraordinary nature of this particular remedy. Now, the purpose of this particular webinar is basically to understand the nature and the various repercussions that this particular amendment may have. So, let us, though I had kind of discussed earlier that we can have questions towards the end, but I would keep on asking you guys if you have any difficulties or any doubts with anything that I have said as of now, because this is what is the foundation for the discussion that I'm going to have. Any difficulties or doubts on any of these fronts that I have discussed as of now? You guys can unmute yourself and kind of speak up, or you can use the chat box as well. Yeah, please. I'm so sorry. Yes.
So I was just going through this particular article which said that because of this amendment, government it has made easy for the government to do businesses. Now, because while reading the section of the amendment, I could only understand that it has just specified, or it has made the made necessary for the courts to give relief under this act and not just optional. So how does it actually helping the government in doing easing the business with this amendment?
Yeah. So my argument on this particular front is completely opposite. It is to say that if you look at and compare this particular thing with the damages regime, it is in some way hindering the business. But what the intention of the committee members, as I could gauge from the report, was that people will start respecting their promises. See, what they committee members were trying to say was that in those cases wherein a particular person breaches the contract, pays some amount, and just kind of gets absolved from his responsibilities towards the other party, breach is a very easy business. You breach and pay money and move. Multi-million companies, multi-billion companies, they kind of do it. They don't. It doesn't take much for them to kind of pay the damages, and they get absolved from all their liabilities just by paying the money. So they basically said that the ease of doing business would be there because people will start respecting their promises. But I'll be discussing all these ideas of ease of doing business and people respecting their promises, right? All these ideas, that how sound those ideas are if we kind of look at the larger picture of the regime of contractual remedies. I shall be discussing that in the upcoming 40 minutes of this webinar.
Does anybody else have any questions?
Okay, so I can I think move ahead. So if you now look at the committee report, it basically gives 4 reasons for why this particular amendment should be brought in. One of the reasons is that there is a moral obligation to perform one's promise. If I have promised you that I would be doing a particular thing, or I would be performing a particular contract in your favor, there is a moral obligation in my favor, in my favor, that you shall perform your promise. And vice versa, that I also have a moral obligation to perform the promise to your benefit. This was the first reason which was given by the committee. The second reason that they gave was that and not an extraordinary remedy, because then people will make promises to perform it, and they shall not have an intention that, okay, fine, we can breach this particular promise at any point of time, right? We can happily breach this particular promise at any point of time and kind of go ahead by paying the damages, right? So that is something which they thought that there will be an ease of business. Thirdly, again, flowing from the second reason of ease of doing business, they said that this will encourage parties to perform the contracts. And fourthly, they said that it is important to remove the inadequacy test that I was discussing with you guys earlier, that where damages are an inadequate remedy, or the damages could not be ascertained, which was an inadequacy test, right? I'll now refer to these two things as inadequacy test in the upcoming part of this lecture. So they said that there is an uncertainty because the courts use their discretion, and sometimes they say that it is that the damages are inadequate. Sometimes they don't say that damages are inadequate. Sometimes they give reasons for why damages are inadequate or not. Sometimes they don't give reasons for that, right? So this leads to an uncertainty in the regime that whether specific performance should be would be given or not, and the decision of the court then largely falls on and relies on the specific performance of contract to be, on the discussion of the court with regards to the facts of the case in that situation, right? So these were the four basic reasons for which the committee uses to justify the amendment. Now, in my understanding, I would intend to kind of further an opinion that these four reasons are not very strong reasons for this particular amendment, especially taking into consideration the kinds of repercussions that it may have on the commons. And the second idea, I'll kind of discuss these ideas towards the conclusion as well, that I intend to further is that this particular amendment not only does create a very cumbersome kind of a remedy or a very difficult kind of a remedy both for judiciary as well as for parties, but also has an effect of taking away the equity from an historically equitable remedy. Now, obviously, if we look at, let me discuss all these four reasons in light of these two primary arguments that I have made here. That if you look at the specific performance of contract per se, and if I ask you that, okay, I have made a particular promise to you and I breach it, what is more just for a judicial system? That should I be forced to perform it, or can I just pay money and kind of go ahead without performing it? What is a more just outcome? Anyone on a prima facie understanding or on a superficially looking at this particular situation would definitely say that yes, it is more just for you to perform your promise. Some will even go to the extent of saying that it is equitable and it is conscionable, right? It appeals to the conscience. If you perform your promise and you do not breach it and don't just get released by paying damages. That is a superficial understanding or a prima facie, even if you don't want to call it a superficial understanding, but that is a prima facie understanding of this particular scenario, that I should be performing my promise and should not get absolved of my liabilities just by paying money to the other party, right? But if we go deep and we look at the roots of this particular remedy and we start then comparing the roots to the amendment, we see that some drastic change, some drastic deviation has been made by the courts, by the legislative amendment, right, as far as this particular remedy is concerned. Now, let us kind of look at these four reasons which the court has given from the lens of equity. I have already mentioned in the beginning of this particular session that specific performance of contract is an equitable remedy, right? It emanated from the code of equity, and one of the reasons that we may be furthering specific performance of contract could be that it furthers equity. But my question is that does a regular grant of specific performance of contract really further equity, or can we look at it otherwise? Can it be inequitable rather? So before I kind of begin with this particular understanding, let me discuss with you what is meant by equity. Can anyone out here from the participants, can anyone kind of have a take or would want to say or discuss that what is it I mean, what is meant by equity, or how do you understand equity in the first place? This,
Hello.
yes, Aviral.
Sorry, speak. Sorry, speak.
No. Please go ahead.
Okay. So what I was saying was equity was more like more like not a rigid or a written principle, but was more like a factor that was used by the court of equity in majority of the cases where the written law was not something that can be used to further the case of justice. So it was more like a application of common sense plus more like a understanding of particular circumstances that was related to the case in hand, and it was used to further the cause of justice even more than the text of the law that is there.
Okay. Any other take on equity? Rishika says that equity is giving one what one deserves to ensure complete justice to the party. Okay. Any other take on what do we mean by equity? It's one of the very common terms that we as law students come across. Equity, justice, conscience. Many times residuary clauses in many legislation say whatever deems equitable to the court shall do things. Okay. So the generic understanding of equity is that equity is something which furthers just consequences where the law cannot grant those consequences. This could be a generic understanding that equity is something which furthers the cause of justice, or equity leads to just consequences. As Aviral mentioned, or as I had kind of, I got a reply on the chat, right? Both these things mean that equity is intended towards just consequences. And that is agreeable. But if that is what defines equity, can we then really say that law is intended towards unjust consequences? Because if you look at medieval England, from where the equity originated, equity and law were two parallel structures of adjudication. And if one furthers the cause of justice, can we say that the other doesn't further the cause of justice or is intended towards unjust consequences? No, we essentially cannot say that, because there are many legal principles which are still applied, and as law people, we many times try to kind of mold them, bring them up front, or apply them as it is by saying that, look, we are furthering the cause of justice. There might be different understandings of justice for everyone, but we many times use law, or kind of at least believe that law is an instrument which may be used to further the cause of justice. Some believe that law is an instrument of oppression. But there is a line of thought which says that law, if it is used correctly, right, may be used to further the idea and intent of justice. So the idea is not to say that equity was just and the law was unjust. And in this particular situation, when the most common understanding, let us call this as common understanding of equity, right, which says that equity furthers the cause of justice, or equity is just, right? If the common understanding does not give us an answer, how do we kind of define, or how do we kind of then say what equity really is? And the scholars on equity have spent their entire life analyzing the judgments of the courts of equity, analyzing the principles that emanated from the judgments of the court of equity, and analyzing several other possible aspects, but they could not reach a cogent definition. They could not reach a proper way in which they could have defined equity. And the best definition, to your surprise, it was to my surprise as well when I read it for the first time, and the most accepted definition of equity comes from one of the scholars in 1900s, early 1900s, named Maitland. He says that equity is something which is a set of those principles which was once governed by the Court of Equity before their abolition. Now, this is the most accepted definition, that whatever principles came from the Court of Equity, those are the principles of equity. That is the most well accepted definition in literature on equity. And therefore, this definition being historical in nature, it becomes pertinent for us to understand that how equity essentially did evolve and how did the courts of equity did perform, because the judgment is set, the definition is centric to the courts. It is not centric to any principle, it is not centric to any idea in equity. It is just centric to the courts, right? So it's a very, very long story of some good 400, 500 years. I'll just make it short in 5 minutes. I don't want to kind of bore you guys by kind of discussing stories, especially in a post-lunch webinar. So, but it's essential. So I'll just take 5 minutes to discuss that story, and then we shall come back to specific performance of content. So the story goes like this, that England in 1000 AD, 1041 AD to be more precise, was attacked or was annexed by Normans, right? There was a colonization of then England by Normans, and English people at that point of time used to reside in small tribes. Each tribe had its own culture, each tribe had its own, customs and laws, which they kind of governed. But when Normans kind of came, there was a Norman king who was governing the court, who was governing the entire England. He wanted to establish his own law as a symbol of his authority over people. So what he did, he established rotating courts. So the court will, on one particular day, will go to a place of tribe A. Next day, the court will go to tribe B, then tribe C, then tribe D. And over a period of, say, a few months, they will have an entire, they'll kind of go to the villages or to the areas where all the tribes used to reside. And they will resolve the disputes there, taking into consideration the laws of that particular tribe. To this extent, it is fine. But now what happened? That Normans were not native English people. They were colonizers. So they were not very well aware of the tribal laws of each and every tribe. So what they had to do, the judges had to consult the people or the local elders of that particular place with regards to what the law on a particular subject matter or the dispute that exists is. And what happened was that in this process, judges felt that it is not logical for us to go to each and every tribe, know their local laws, and every time consult the elders and then talk about things and stuff. It is something which is an extremely cumbersome process. So what judges started doing, that whatever kind of dispute has once been settled by a particular law, that law shall prevail and govern all the tribes. So say, for example, say dispute X arose in tribe A, which has certain customs, and that got resolved according to their customs. Afterwards, the dispute X again arose in, say, tribe B, and tribe B has completely different customs from tribe A, but the customs of tribe B will not be taken into consideration. The judges will apply the rule which kind of came up from the tribe A's customs to tribe B as well, right? And as a result of which, the very first time whenever the rule evolved in whichever tribe, that rule governed all other tribes. And the law which came from these common principles, which governed all the tribes, right, in England, and the law which became common to all the tribes in England is what is called as the common law. It's not the law which governs the Commonwealth. It's not the law which governs all the colonies of England. No. In its true historical sense, common law is that law which commonly governed all separate tribes, which were essentially being governed by different rules of their own, and now there was a common law to govern all of them. That is the understanding of common law, the most frequently used term when it comes to contract or tort or subjects like these. That is the understanding of common law. And now what happened, that because of this evolution of common law, what lied at the heart of it was the doctrine of precedent. Because once the court has pronounced a decision in a similar kind of facts in tribe A, the court will pronounce similar decision in similar kinds of facts in tribe B, irrespective of their customs. So doctrine of precedent became a front. It became very important when it came to the idea of specific performance of, when it came to the idea of the common law. But because of this doctrine of precedent, there was an inherent rigidity in this entire system of common law, right? And that rigidity, because judges were just following the previous decisions, they were not coming up with new. The society changed in coming 300 and 400 years, but similar laws were being followed. Now it's a long story, I'm just cutting it short, right? And therefore, there were poor people, there were rich people, and this rigid system was not conducive to the poor. So poor started approaching the king and saying, look, this system is not conducive to us. You please give us some kind of relief by your residuary power of justice in the name of God. And the king then said that, okay, fine. He furthered those applications to his prime minister, who was the chancellor and resided in the chancery, right? And now the chancery came up, and because that was a particular point of time when the king and church were kind of not two different entities. The law was governed by the church, there was religious law. So all the people in the courtiers of the king, including the chancellor, were the people of the church. So initial chancellors, if you look at them, they essentially were bishops of they essentially were godmen, or not exactly godmen, but were religious men, right? What in scholarship we call them as ecclesiastical chancellors, who essentially had their origins and root of their understanding of law in the religious laws, right? So these people, when they assumed the office in the court of chancery to adjudicate over the disputes, these people, they started invoking religious principles. But one thing that they always made clear was that we have come into existence after the common law courts, and therefore we will always consider that they pre-exist us. On any point, on any matter, wherever common law courts can produce a just outcome, we will not interfere with that particular matter. It was very clear to the chancellors, were very clear to the chancery and equity, right? And therefore the understanding in the English law was that equity follows the law, which means that equity always concerns the pre-existence of law. Equity always considers that the law exists on a certain point, and if it is convinced, the equity court is convinced that the law gives certain outcomes or will give just outcomes, in that particular case, equity court will not interfere with those particular areas or with those particular domains. This was the understanding of the court of equity in the medieval England, right? Now, only to this extent this story is important, that equity was meant to follow the law, to the extent that some of the celebrated scholars, I again quote Madeline on this, he says that equity without law is a castle in the air, which is an impossibility, right? That without law, equity cannot exist. Law can exist without equity, but equity cannot exist without law, because equity's purpose is to mitigate the rigor of the law, right? So now we kind of go ahead, and with this understanding that equity follows the law. Now, if you look at the inadequacy principle in specific performance of contract, I'll now contextualize it in specific performance of contracts term. If you now look at the inadequacy principle, that damages either are not adequate remedy or cannot be ascertained, it's in only those cases that we will grant specific performance of contract, because then the aggrieved party is left with no other remedy in law. Remember, damages are a common law remedy, and specific performance of contract is a equitable remedy. So it is only granted when the legal remedy fails, or when the legal remedy is inadequate or cannot be ascertained. So equity pre-exists the existence of common law remedy of damages, and wherever it is possible, it will not grant its own remedy of specific performance of contract, but will rather grant a remedy of, rather direct the party to the common law courts and say you go and get damages from there, right? So that is the idea. Now, if you look at the removal of the test, inadequacy test, it essentially leads to a certain kind of uncertainty in the commerce. Though the committee says that existence of inadequacy test leads to uncertainty, I would rather propose to say that the removal of the inadequacy test leads to uncertainty. Why? Because earlier it was clear, at least the remedy was clear, that if I have breached the contract and damages could be granted, I will pay the money and go ahead. Now everything is at the sweet will and whims of the party who is aggrieved by breach. It will go, it may seek for such a performance of contract, it may seek for damages, it may seek for both. And if you look at the commercial world, it doesn't operate the way we teach contract in the classroom. The commercial world, there is a very great aspect of risk assessment when it comes to entering into any specific contract. And one of the risks that is assessed is also that suppose if we are not able to fulfill the obligations owing to any future circumstances, right? In that particular case, will we be suffering a greater loss than the possible profit that might come to us from this particular contract? But when the regime is uncertain, right? When the regime is uncertain, when you don't know the sweet will of the other party, how do you assess the risk? And if you are not able to assess that particular risk, you essentially fall for a great amount of uncertainty, because as a commercial party, you might enter into a contract apprehending some profits, could not perform it, maybe not for a malice on your part, but for something which kind of prohibited you from performing it anyhow, but law doesn't recognize that as frustration, say, right? In that particular situation or circumstance, how do you then really say that specific performance of, how do you then really say that what will be my loss? Because other party may require me to perform it specifically, I may go bankrupt performing it specifically, and other party is not satisfied with damages. So though inadequacy test removes the uncertainty of saying that specific performance of contract will always be granted whenever it is sought, but when you say that it can be sought at the sweet will of the party who claims to be aggrieved in a particular case, or who is the claimant or plaintiff in a particular case, you induce a greater uncertainty, not in the courtroom system, but in the larger commercial system. Because the parties cannot assess their risks anymore. So that is one of the issues with this routine grant of specific performance of contract. Other issue that comes up is that specific performance of contract is essentially much more difficult remedy even for the courts to administer. See, as a court, I have to tell you that you have to pay a certain amount of money to Mr. X. It is very easy for me to secure the performance. I can either take a security deposit from you in advance to say that, okay, you first give me the money because I see you in fault, and it's only then that I will go ahead with the adjudication process. If that is not the case, I can instruct you to pay on execution. If you still don't pay, I can attach your property. If you still don't pay, I can sell off the attached property, realize the money, and pay the aggrieved party. Any of these things I can do, it's in my hand. By appointment of receiver, I can do all these things. But if I require you to do a particular thing and you don't do it, how do I ensure that you perform it? The only ways that I have are by putting you into civil prison, or by kind of pushing you, or by kind of issuing a contempt against you, right? Attachment can again be coercive to you as a person who has breached a contract, but still cannot ensure specific performance of contract. So it becomes very difficult for the courts to execute such remedies, which are in the nature of injunctions, or wherein the court requires a particular party to do or to abstain from doing a particular thing in light of the provisions of a certain contract. So it may induce a certain kind of certainty in the courtroom procedure, but at the same time, when it comes to execution, it leads to very different kind of absurdities and very different kind of difficulties on the part of the court. And it's not only on the part of the court, also the party who is pushed to perform such a performance of contract by way of contempt and other things is hugely coerced as compared to when it would be, as compared to paying damages. Because you are pushing a particular person to do a particular act by a legal ordinance or by a legal command, right, which he doesn't want to do. And even if you kind of require him to do that, there will still be he doesn't have resources to do it. and you push him to do that particular thing, it might be a possibility that he may deliver that particular performance, but not truly in essence. So the party seeking for such a performance of contract remains unsatisfied. The party giving the specific court is also putting in more labor and more supervision to kind of do this particular thing. So at the execution front, it causes a lot more coercion and a lot more uncertainty than we can essentially think of. And why am I saying? Some of you might kind of feel that this entire explanation that comes from me, or this entire argument that I'm kind of building out here, is in favor of the breaching party. Or why am I favoring the breaching party? See, my response to that would be that idea is not to favor a breaching party, but the idea is to consider both the parties, be it the claimant or plaintiff or the defendant, as commercial parties. And the purpose of the commercial law, be it grant of damages or specific performance of court or any other thing, the underlying purpose is to grant justice, which essentially emanates from the idea that the commercial well-being should be maintained. The idea in the commercial law and the idea of the courts in the commercial world is to maintain the commercial well-being. That the commerce should be certain, commercial parties should not be exposed to exorbitant burdens, because if you kind of say, it's not just one case, right? Say 5 cases in which damages could have been granted, now specific performance is being granted, and the parties are coerced. They are in a much worse off position than they would have been if they would have granted the damages. But now they have to perform specific performance. If you multiply this and you kind of look at the number of cases across the country, a large number of commercial parties would be subjected to coercion, or would be subjected to these kind of harshities, and essentially that doesn't further the commercial well-being of anyone, right? Why do I say anyone? I'll come to that, right? So it imposes an extra burden on commercial parties and leads to inefficient consequences, right? Any questions till now? Any comments, questions, difficulties? See, Specific Relief Act in terms of specific performance of contract is not a law which largely creates a substantive law. It creates a law of remedy, right? The chapter on specific performance of contract. And when you say that the law concerns itself with remedy, any law which has a contract, be it Transfer of Property Act, be it an insurance agreement, be it a credit facility agreement, be it any commercial transaction which cannot be done but for a contract, this particular amendment intrudes into that particular area. Because specific performance of contract is not something which concerns itself with one particular law. It concerns itself with every domain of commerce which has an involvement of contract. Yes? Yeah? Any other questions, guys? Fine, so I think I can safely move ahead. I am making sense to all of you.
Yes, sir.
Yes, fine. So now let me make this discussion a bit more twisted. In this entire understanding of saying that damages are not an adequate remedy, or sorry, damages essentially cannot further the idea of justice and stuff, and therefore specific performance of contract should be there, and all these things. Let me look at damages. What damages really are? Are damages really inequitable? Though they are common law remedies, but are they inequitable? Sometimes you may feel if you just don't look at from the angle of aggrieved party, you look at the larger idea of commerce that the commercial law has in its mind, you will sometimes feel that certain aspects of damages are much more what do you say, are much more equitable as compared to specific forms of contract wherever they are applicable. I will take two examples. I'll take two cases with you and I'll discuss that. One of the case is the case of British Westinghouse versus Underground Electric Railway Company. It's an English decision, but that doesn't matter. The outcome and the facts are very important for this case. What happened in this case? There was a particular company who had given some of the turbines that it had or which it used to operate for which it used to operate for electricity generation to a particular turbine repairer. And the turbine repairer was used to repair the turbines and give it back in some time. The repairer did repair the turbine and he gave it back in time, but the repair was not proper and the turbines did not function properly. As a result of which, these people, they had to and some of the turbines were not even delivered on time by the repairer. Now what happened, that the turbine company or the the company which was engaged in production of electricity, what it did, it essentially went ahead and purchased new turbines and applied those new turbines to the performance of their duties and electricity generation. What the facts, as they say, and the statistics as they kind of come up in this particular case, were that the turbines which were new, right? The turbines which were new, they were much more efficient than the old turbines, even if they would have come after repair. And as a result of which, a large amount of loss which the companies suffered because of non-delivery of turbines on time was slashed, because the new turbines were much more efficient, they produced much more electricity, and the company could generate profit, which kind of mitigated the loss which otherwise would have happened. And in this situation, the question before the court was that should this efficiency of the new turbines and the resultant mitigation or slashing of the loss be considered in reducing the amount of damages which the contract breaker or the company which kind of produces the turbine has to grant to the other parties, right? And in such situations and circumstances, the court ruled that the efficiency in the new turbines, though is not attributable to any act of either of the parties, but the loss has reduced, and therefore it is only the reduced loss which will be granted to the party in this particular situation. Now, if you look at it from the angle of the well-being of the commercial party, both the parties, if you see, the party who has suffered the breach, it could reduce its losses because of that extra efficiency in the turbines, right? And therefore, even if extra amount would have been given to him, that would not have been just. And the party who is to pay the amount, or who is the contract breaker, his or her burden has also been reduced. And therefore, commercially, it is also well off. So no party, the damages have got reduced. One party is well off, and other party is also not affected severely or in a bad fashion. Isn't it a just outcome? On the other hand, if it would have been forced to deliver those turbines at extra cost, it would have been coercive. It would not have affected the other party quite greatly because they already have new turbines. And at the same time, it would have acted to the detriment of this particular party. And therefore, to say that damages are remedies in law and are not equitable in nature is not a very good idea. Right? Similarly, if you look at a very famous case of Headley versus Baxendale, any class on damages, it starts from this particular case, right? Headley versus Baxendale. I don't know if I have to repeat the facts of that particular case or not, but I will repeat, considering that some student might be a first semester student or a first year student who has not kind of read that case as yet. Yeah. 10 minutes. 10 minutes. I am concluding. Yeah. So, if you look at the case of Headley versus Baxendale, in that particular case, there was a mill, a wheat mill, whose crankshaft got broken. And the crankshaft was sent from the place where the mill was placed, like Gloucestershire, to Greenwich, to engineers for making that crankshaft. Right? Now the crankshaft was sent. What the transporters of the crankshaft did, they sent that particular crankshaft. They got a bit late in transporting that, and as a result of which the mill was stopped. Right? The mill was stuck, and there were losses which were suffered by the mill owner. The mill owner filed a case against the transporting agency saying that I have suffered a loss because they did not perform their part on time. As a result of which, what happened? The matter went to the court, and the court was here to consider that should the party be required to pay damages or not. And very famously, those of us who know, the court ruled in favor of the transport agency, who was termed as contract breaker by the mill owner. And the court said that there are several possibilities. It is a possibility, this is a very specific possibility, that the mill had just one machine and one crankshaft. There is also a possibility that might have been one more crankshaft spare with the mill. There is a possibility that the mill has some extra machines with it, or there are 2 or more machines in the mill, and therefore the entire business of the mill has not been stopped. Considering all these possibilities, what the court said, that you cannot really put the burden on the transport agency of the facts which you never told the transport agency. You never told them that you just have one mill, or you just have one machine and one crankshaft, and your mill will be stopped if it does not happen. The facts that you had not informed him, you cannot put a burden of those facts on the party. And therefore, the court did not grant damages to the other one, right? And therefore, a remedy, just because there is a breach of contract, it is not essentially the remedy would always be granted. Just because of specific performance should be granted, I'm so sorry, right? And as they say that the parties will be encouraged to perform their contract, or there will be a moral obligation to perform the promise, as they kind of say, it is not always essential for the moral obligation to be brought in, because when you are talking of commerce, you should be talking in terms of what is in the well-being, or what is it that the commercial well-being of the party requires, right? And therefore, in such cases, situations and circumstances, what we essentially need to understand here is that I come back to my original argument that this particular remedy or this particular amendment of specific performance of contract not only is based on some reasons which are not that sound. I have discussed the reason of moral obligation, certainty, ease of doing business, and parties to perform that, how we can refute those reasons in the larger understanding of the in the larger understanding of the commercial well-being of the parties, right? But it also, and this is a very grave thing to say, but it is true in this situation, it also takes away the equitable aspect from an equitable remedy. It has now become coercive. It has now become something which is draconian in some ways, right? So equitable remedies remain equitable only when they are applied in the fashion when equity follows the law, especially in specific performance of contract cases. And therefore, this amendment, to my understanding, might seem on the face of it to be very just, to be doing or coming up with very reasonable arguments and stuff and doing something which should be done. But at the end of it, if we kind of dig deep into the jurisprudence of equity and kind of look quite closely, the understanding of of this particular remedy and damages, on the other hand, it may result into some very grave and disastrous results at times. And with this, I kind of conclude. Any questions, any doubts, any discussions on any front are most welcome. I'm looking forward to that. Any questions before that? Fine, no question, that's fine. I am quite tired. Speaking for an hour in front of computer, I am also tired. Fine. Can I talk about liquidated damages? Yeah. So liquidated damages, if you kind of look at them quite closely, is another very twisted and a very complex area in law. The liquidated damages regime is even more uncertain than we can think of when it kind of comes to specific performance of contract, or the kind of uncertainty which they kind of say exists in here. But the question is that, can we have liquidated damages and specific performance of contract at the same time? Right? So there is one section in specific relief, and I think it's section 23 of the Act, if I'm not wrong, 22 or 23, which kind of says that the court can also grant damages along with specific performance of contract wherever it feels that it is just, right? But liquidated damages, again, in its generic sense, is an area which is, because what the court sometimes do in liquidated damages is this, that the court, you go to the court and say there is a liquidated damage clause that I have. The court will say no, this particular clause is not a genuine pre-estimate of your loss. It is much higher than what you would have got if you would have filed a case for unliquidated damages, and therefore we will not grant you liquidated damages in this case. Your clause is redundant. It is rather, if you call it technically, it is in the nature of penalty and not in damages, and hence you will not be given this particular relief. And the courts start kind of discussing the idea of unliquidated damages, and they quantify the damages according to the unliquidated damages regime. When the courts will consider LD clause as penalty, when they will not consider, it is completely on the whims of the court. But if we kind of look at it from the angle of specific performance of contract, sometimes the courts, if they feel, right, sometimes the courts, if they feel that specific performance of contract can be granted, specific performance of contract cannot just fulfill the remedy, and then there is a LD clause. In that particular case, the LD or liquidated damages would be granted along with specific performance of contract, because the party might say that because of this delay in the performance, I have already suffered a kind of loss. There's a follow-up from Garima. It says that if I do have a clause of LD, am I restricted from my remedial rights under law, including specific performance? No, you are not restricted on that particular front from your right on specific performance of contract. But what you can say is that this liquidated damages clause has been entered into or should be used, right? That depends on the drafting of the LD clause. If the LD clause says that it is just the liquidated damages intended by the party, then afterwards the change is a bit difficult. But if it is in the nature to say that the LD clause exists, you may say, grant me specific performance of contract, plus I also want additional damages for the breach, and I should get LD for that. Does that make sense, Garima? Okay. Then nice question, and insightful one, I would rather say. See, a termination contract or a contract with a termination clause does not mean that a contract is determinable. But a contract is determinable will always be the one which has a termination clause. I'll discuss how. A determinable contract basically means which at any point of time can at a sweet will of party be determined. Let me discuss one example. Partnership at will. In partnership at will, you say that there is a particular party, right? And the partners have created a partnership at will, and any partner can at his or her very sweet will dissolve the partnership at any point of time. Now, if partnership is at will, one partner is not performing his obligations. I go and file a case of specific performance of contract, and that partner says that even if you specifically perform the contract, I will bring the partnership to an end. Now, in this particular case, even if the court pushes for specific performance of contract, and the partner at his sweet will dissolves the partnership, in that particular case, entire exercise of years which the court kind of undertook goes redundant. But if there is a termination clause which is contingent, which says that if you don't perform your part, the contract will get terminated. Now, this is not something which is terminable at the sweet will of the party. Though there is a termination clause, though it is determinable, but determination aspect is beyond the control of the parties. And those particular things are not covered under the term determinable when it comes to section 14B of the specific relief. So it's not always, now I come back to my starting statement, it's not always that a contract with a termination clause will be determinable, but a contract cannot be determinable but for a termination clause. I hope I make sense when I say so. Is it clear, Rishika? She says that is the contract between X and Y, it is terminable by X. Can X file for specific performance of contract? Yes. He can file or she can file for specific performance of contract because Y doesn't have authority to terminate the contract, and the party who says that it is determinable can file. But in that particular case, the party will have to write, X will have to write in his or her plaint that I, at all point of time, had been ready and willing to perform my part. And if the court passes a decree, I would still be ready and willing to perform my part. I will not determine the contract then. Because once a decree is passed or specific performance of contract, then it is no more the contract which prevails. Then the decree will override the termination clause. X cannot say that I have a determination clause and after getting the specific performance of contract decrees, I will terminate the clause. Because the court is now asking you to perform it, so the decree will take a precedence over the termination clause and decree will get executed. But if X part is based on his skill, see, he or she will have to kind of say that I will perform my part of the contract. Essentially, it's only then that if the court feels that either he or she is incapable or unwilling to perform, in that particular situation or circumstance, in that particular situation of circumstance, it would not really be that great a thing. The court will not grant specific performance on that case because see, if you look at section 11 of the section 10, it says subject to limitations under section 11, 14 and 16, right? And section 16, if you look at there, it talks about mutuality clause, but we call it term of mutuality in specific performance of contracts. Term of mutuality is this, that the party seeking for specific performance of contract should at all point of time be ready and willing and should convince the court that I am ready and willing to perform my part. If you cannot do so, you will not get specific performance of contract, and that is a limitation even under section 10 which uses the term shall. Is that clear, Rishika? Okay. Thanks a lot for the question. It was an insightful discussion. Thanks a lot for that, Rishika and Varun.
Shall I proceed, ma'am? Good evening, everyone. I feel privileged to propose vote of thanks on behalf of Team The Blawq to our guest speaker Varun Malik sir for taking the session today on the very important topic of amendments to Specific Relief Act 1963. The session was so informative and insightful, sir. Further, I would extend my gratitude to all the participants and attendees for gracing the session with your presence. Thank you.
Thanks a lot. It was a pleasure to